Mr. Vijay Hansaria, Learned Senior Counsel, any other Learned Senior Counsel who is present here. I know, learned office bearers of the Scaora and aspirants of the AOR examination. Now I think it will be more of an informal speech. I have not come here to give a lecture or to introduce you to the rules and all that. That is not what I intend to do. Probably Mr. Hansaria will do that, because we rose late and have to go early also. But I would like to first of all wish all the aspirants the very best in their preparation, and also that they should come out with flying colors. But my impression as an advocate who used to send cases to the Supreme Court from the High Court, where I was practicing in Karnataka High Court and trial courts, and my interaction with the AORs, and what is the importance of the AORs in the Supreme Court, I would like to highlight, because you are all wanting to become advocates on record. And after being in the Supreme Court for about 1 year and 3 months, etc. See, my impression is that the very functioning of the Supreme Court is on the strength and the contribution of the AORs. The AORs are really the fulcrum of the Supreme Court, so to say. Every brief that is filed has a parent, and that parent is the advocate on record. You are so central to the brief. It may be that there is an advocate from the High Court or from any other court or authority, maybe tribunals or whatever, who would send the brief to another advocate. But that other advocate cannot file any case except through an AOR. I think that is the essential understanding. Now, the reality is the AORs may get briefs on their own, because that is how the tradition has been. Most of the AORs come from separate various states. They all visit the various states during the holidays time. We see them in the High Court, and their briefs are handed over. I am now speaking as a High Court advocate, let us say. Briefs are handed over to them. They collect the briefs, get the briefings, and then they come and file, because it is only through them. Or another advocate who would have received a brief to be filed in the Supreme Court has to approach the AOR. He may not know what the case is about. He may not have contacted the client. He is only in interaction with either the advocate in the state or High Court, or the advocate who is practicing in the Supreme Court, who would have got the matter filed through him. But it is only the AOR whose name appears on the file who is responsible for the brief at all times. Now, what is the position of an AOR? He is responsible to the advocate who has sent the matter from the state, let us say, or another advocate who has received the matter from the state High Court, who is in Delhi and who takes the assistance of the AOR for filing. He is the one who is responsible to assist in not only the filing, but afterwards to ensure that the matter comes up before the court. Between the two is an important stage. One is filing and the matter coming up. What is that? There should be no defects. If there are defects, he or she interacts with the registry to ensure that the defects are removed. So the AORs must be very, very proficient in the format of the filing in the Supreme Court, whether it is an SLP, whether it is a writ petition, whether it is a statutory appeal, whether it is any other form, election petition, appeal, or therefore all of you must, apart from studying and passing as AORs, be familiar with the formats of each of the types of filing. Yes, civil SLP is different sometimes, I think, from a criminal SLP. An election appeal is different from a statutory appeal. So there are formats. Please know the formats of filing of each of these SLPs. There are checklists. Study those checklists and have the copies of the checklists. I don't know whether they are exhibited on the websites of the Supreme Court website. Study them so that it is as per that checklist the filing of the SLP or appeal or statutory appeal, election appeal, whatever has to be done. So therefore it is your duty, because that is where your expertise is taken, and you are the only person who has the duty coupled with responsibility, coupled with right, or whatever you may call it, the privilege to file a case in the Supreme Court. Nobody else, unless he or she is a party in person. Therefore you should know that. The expert should know about the format of filing so that your interaction with the registry is very less and the matter comes up fast. That tension is not there, because you are answerable to the advocate who has sent it from, say, Bangalore, Chennai or Calcutta, or to the advocate who has brought the file to you to file it. As far as possible, please be familiar with the matter. Please read what is, suppose you are asked to draft it, you have to study the impugned judgment or order and then draft the SLP if it comes directly to you. Therefore you are again to know what the substantive law is, what the procedural law is, reading the judgment, etc., making the grounds, etc. Sometimes you will get a ready-made grounds. Ready-made SLP, or to only put it in the format they would have drafted it. Please be careful to read all that and just don't put ditto, because in one case we have issued notice with regard to something which was found not palatable to the court, and therefore you must read everything. If you are making the grounds, you will definitely read. You will not just make grounds, formulate grounds without reading. If you are getting a ready-made SLP, greater responsibility to know what is submitted to you, either from the High Court side or various parts of the country, or the advocate who gives it to you. If he is a person who is seasoned, he knows how it is to be drafted. But if a young person comes, there may be problems of language, grammar, appropriate words being used or not being used, and how the entire format of the SLP or civil appeal or whatever has to be filed. So that is there you have your, apart from your liaising, in the sense liaising means interacting with the registry to see that there is no defect or what you call defect in the SLP, so that it comes up on time. You are also responsible for ensuring, I think, that it is listed. Now, even for listing, you may take the assistance of senior counsel or other counsel, because the person who has said please get it listed, interim order is required, etc., etc. Therefore, for listing there should be no defect. Then once it is listed, again, whether the person who has given you the brief will argue, or somebody from one of the places anywhere in the country who has sent the brief will come, he or she will select the senior counsel or rely upon you to select the senior counsel to brief. Then you have to take that person who has come, and that responsibility, he or she will depend upon you. Take me to the particular senior counsel whom you have selected or he would have selected for the purpose of briefing. That will also be there. You become a briefing counsel, apart from a counsel for filing, a briefing counsel. So you should know the case. You should now know how to deal or interact with the senior counsel. All senior counsel are not same. Each one has their own temperament, their own problems that may throw. Mr. Vijay Hansaria is here to, I think, to say my statement is true. No? He is a senior counsel, but he is a pleasant person. Not everybody is like Mr. Vijay Hansaria. So you have to know the case. They'll throw the file at you, otherwise, and your reputation with the counsel who has come from the state is involved. I'm just telling you all these things which you may know, but your responsibilities I'm just highlighting. Other things you may read from the book, but practical tips I'm giving you. Then afterwards, again the matter has to come up. You keep seeing the board, whether it's reaching, get the senior counsel, and then ensure that the matter is taken up. So they're all tension areas. And sometimes what happens, we find that the AOR is not present in the court. Why? Because he has been engaged only to file. He doesn't know anything about it, and that person who has come from, let's say, Calcutta or any other local counsel who has got the brief, he is really in charge of the brief. He will engage the senior counsel. You don't have to do. He is a Delhi Supreme Court lawyer. He knows all the entry and exits of the court. You don't have to take him, because when we used to come, we used to depend on our AOR to get us the pass. We used to go and we used to eat with them, have coffee with them, show us the entry and exit, and then keep our luggage in their room, and then go back to our place after the case is over. So many things you have to take care of them, because it's all goodwill gestures, no, so that they continue to send the briefs, what they call feeding, no? Yes. So apart from all these things, that kind of goodwill gestures you will have to show. Now sometimes AORs are not present in court. According to me, unless the AOR is arguing a matter in some other court where he or she has not engaged a senior counsel, and he himself is arguing, there are many cases where the AORs argue on themselves. They have to be present, according to me, when their matter is going on in any court. They cannot be, outside the court hall when their matter is going on, because AOR is primarily, I told you, the parent. Something is missing, some paper is missing, something is not filed. Who is answerable? The person who has filed it. Unless that person is not able to be there because he or she is arguing on his legs in some other court, please ensure that you all are present in the court when the matter which you have filed is coming up before the court. If many matters are coming up at the same time, then you have to see which is more high stakes, whatever, which counsel you will have to support, or what stakes, and which court, what problems, which bench. All that you will have to weigh your options and be present. And then of course you will have to, if an interim order is passed, dismissal, leave granted, whatever, you have to communicate to the local council or whatever. And sometimes it may happen that nobody is there to hold on to that brief. Either the council who could not come from, let's say, Chennai, or any other person. Then how are you going to deal with that brief? It has come up. You should know something at least to say in the court, not just a filing counsel. You are an advocate basically. Incidentally, you pass the AOR exam, you get a privilege. But if they remove this AOR tag, everybody can file in the Supreme Court. But AORs are given this privilege because it is these people, advocates, who are within, I think, some radius in Delhi, etc. For the purpose of service. India is a vast country. For the purpose of service of IAS or whatever, the advocates, that is very rational for it. You can't be in all over the country and file. But, the threat of virtual hearing would mean that there can be virtual filing also. Then what would happen to the AORs? So therefore, you must ensure that your position is maintained. For that, you must see that you are required. you must become inevitable in the Supreme Court so that tomorrow they should not say you can file it from Calcutta, you can file it. AORs are not required. That situation should not come. You should be so inevitable, and that system must continue. Therefore, how you as a group of AORs are going to make yourselves inevitable is by being present, and all these things you have to take care, which means that people depend upon you. The party or the briefing council or the council who has brought the case to you, or somebody who has sent it from Andaman or even Kanyakumari, Kashmir, wherever, etc. You must have this goodwill gestures towards all your persons who are going to give you the cases, and right from the time it is filed till the matter is disposed of and beyond, till you give the certified copy, etc., you are the parent of that case. So therefore, please keep this in mind. The entire Supreme Court, according to me, functions because of the efficiency of the AORs. And it is a skill coupled with expertise, coupled with responsibility. And you will have to inform if you have engaged the counsel on your own, what happened to the case, etc. Give a copy, talk to the senior, whatever, all that you would have seen, because you are all, I think, 5 years. What is the minimum practice?
Yes, 5 years.
5 years you would have known all this, observed. But what I am trying to emphasize is your role is very crucial, and therefore your presence in the court, as far as possible, when your case is listed, ultimately whose name is shown in the cause list? Do they show only AOR's name is shown in the cause list? Therefore, your presence, even if you have done nothing except sign the wakalat or done nothing except sign the memorandum of SLP, you should still be present on that day when the case is coming up, because you are really handling the whole show for that particular case, and take responsibility for the brief. No brief should go without the parent. Dismiss for default or anything like that. Therefore, you are really the fulcrum on which the entire Supreme Court functions. You have this privilege, you have this responsibility, and please ensure that the position of the AORs is inevitable in the system in Supreme Court. They should not do away with it, because now virtual filing is there, virtual hearing is there. Then why everything? They can scan copies, no? And what you call serve copies by scan. That should not undermine your position in Supreme Court. That is what I am trying to say. Then, of course, you should know the Supreme Court rules through and through, because it is through those rules only you are filing all the formats, etc., which I told you. Then this human resource management, council coming from some state. A Bombay council is different from a council from Chennai, who is different from a council from Bhubaneswar, who is different from a council from Lucknow. You should be able to know human resource management, how you are going to talk to them, how you are going to make them comfortable. Because normally, I think the counsel from the high courts, they usually have 1 or 2 AORs. They won't give every case they get to different AORs. They normally have 1, 2 or 3, correct? So you must also retain your position with the council throughout the country. If you are having a particular state, well and good, or 2, 3 states, well and good. This is all part of your relationship which you have, the goodwill that you generate, and once, I am telling you, once the council from any state finds that you are responsible for the brief, yes, if I have handed over, that is enough. That council will not come at all. They will really trust you. So that kind of trust you must build with initially, because it's like a new entry. When you enter the bar, what you have to do? When you start your own office, how you have to be. So now you will enter this particular position. There again, it's a new, you see, entry, and you have to see that you maintain all these things in order to sustain yourself as an AOR, and ultimately see that you graduate from being merely an AOR to an arguing counsel and to a senior counsel, and if you are really good enough, to a Supreme Court judge or a High Court judge. That should be the kind of ambition that you must have. Am I not correct, sir?
Yes.
That should be. Don't continue to remain, I am an AOR, I have achieved everything in life. No. That is only a first step according to me. Second aspect is those AORs who are lucky enough to get the cases from a particular state because they have come from a particular state, Orissa or Madhya Pradesh. Many of them, they go to the particular high courts in summer vacation, December vacation. They go and interact with the counsel who have sent them the briefs. You please do that. And what I used to do as an advocate in Bangalore was, when my AOR came to Bangalore in summer holidays, I would call all my clients who had cases in Supreme Court to my chamber, and the AOR will also come, and he will ensure that he interacts with the client face to face. If he knows the language of the client, local language, if he belongs to that state, well and good. See, that face to face interaction is missing in Supreme Court. That is most crucial. The tears in the eyes of the clients, the anxiety in the face of the clients, the tension that they have is something which you must realize, and which, because of your position here and the distance, etc., you cannot really fathom it or gather it from your client. But I used to do that kind of liaising between the clients and my AOR, who would understand what has to be done. Some IA has to be done there, and then affidavit would be signed, etc. I would give my office to him, and he would take back and then give the verifying affidavit, whatever, that kind of a thing was done. So if you are going to the respective states, when you are interacting, if there is any problem, you tell your client, the advocate, who has sent you the brief, look, I would like to discuss on this aspect. The client and the advocate would be so much grateful to you, because you would have cleared, especially if you are arguing the matter, or even if you have to brief the senior counsel for getting a clarity. See, the system is such that you are not able to meet the client, or you please have a Zoom meeting. Now we have virtual thing. Have a Zoom meeting with your client. Every client cannot come to Delhi and interact with that person. What exactly is the problem in that thing? Why this document was not produced, or why that document was relied upon, or any other particular query you want to ask. You can have FaceTime now. FaceTime is also there. It will be very much appreciated, because you will get the human element of the case. Not that you don't realize it, but you will get it in reality. Otherwise, you would have discerned it on your own. Those who have the ability to discern it, they would have discerned it. What is the problem in the case? But now, when they come and tell you either on FaceTime or Zoom meeting or face to face, when you go there, you will know what exactly is troubling the litigant and how you have to tackle. The litigant himself may give you the answer to the query which the advocate was not told. So These are all some of the tips which I am giving as a practitioner, what I had, and how you can build up your advocacy as an AOR. As I told you, not just remaining as an AOR, but as moving up the ladder. With these few words, I think I must make way for Mr. Vijay Hansaria, because all the other things he will be knowing better. I am a baby in the Supreme Court. I've just come only last year, and I don't know much beyond this except my observations which I had. I am telling you, like, to be present or whatever, your interaction with the various stakeholders, etc. And the interaction with the persons who depend upon you. You must know that persons are depending upon you. Distance is an important aspect in India. Distance. How many times the advocate can come to, deal with the matter, a brief, etc. Nobody will come by train now. Those days are gone. People coming in train, they were doing it in the 70s and 80s. Now there are flights, but what about the expenditure? How many times can the briefing council come? You please take the lead in the matter. You take the initiative. You know what the court is asking. You should be present with the court for that. And I am sure if you follow some of these aspects which I have mentioned, you will all be really successful, not only in your AOR examination, but subsequently as AORs, and you will progress as advocates in the Supreme Court. With these brief words, I thank the President and office bearers of the Scaora for having invited me to share some of my views. See, I had prepared something, but nothing like talking from experience. If I sit and read this or stand and read this, it will be like just a classroom kind of a thing. But this is something which I have spoken from my heart and from my mind, and I'm sure that with this kind of small what you call talk which I have given to you, it will be of some help to you after you pass the examination. You can study the rest of it. And the other aspect is, of course, professional ethics, which I am supposed to talk actually, which I have given you now. Rather than professional ethics, I thought I'll give you some tips to be a successful AOR. Professional ethics you have studied in the law college, you have observed senior counsel, you have observed the court, where the court reprimands somebody. All these things you have already been lawyers and advocates. That is something which you will learn. But there is always this professional ethics is something which you must always keep at the top of your mind. Very, very important. Not just for AORs, for any advocate for that matter. When the matter is on, what kind of interaction you would have with the opposite advocate? If it is for a purpose of a compromise, according to me, when your matter is going to come up, you should not exchange any pleasantries with the opposite counsel. Let them think that you are very, that you are very not the person who is very pleasant or anything. It creates a psychological dent, because I feel that you will lose that kind of vigor which you would have to argue your matter, even if there is some kind of pleasantries exchanged with the other side, psychological, unnoticed. Therefore, keep to yourself, read your brief. I am reminded of Mr. P.P. Rao, the great senior counsel whom I used to brief, how much of notes he used to make. Till his matter is called, he is reading. I am sure you would have all observed him, the senior members. Till his matter is called, he is reading. He will ask you questions. And there's nothing light in this profession. You have a unique privilege. Ensure that you are inevitable for the functioning of the Supreme Court. Thank you very much.
I'm thankful to the office bearers, Mr. Debra and Puneet, to invite me and share with you my thoughts on today. He introduced me in a big way. I was not that big, and I was an advocate on record for 17 years, I think 1985 to 2002. When I changed my counsel, but in heart I remain an advocate on record. I am always an advocate on record. And I strongly disagree with Mr. Justice Nagarathna. If she was here, I would have said, you are not just a filing advocate. You are the advocate in the Supreme Court. Ma'am said that you have to interact with the local counsel because Justice Nagarathna as a counsel had that exposure to the Supreme Court that she comes, she sends the brief, and that's the work of the advocate on record. That is not the work of the advocate on record. The advocate on record that you are the parent, you are the guardian, you are not only the parent, you are the guardian. I think guardian is more important than the parent. Parent is biological parent. You become signing, you become the biological parent, but you remain the guardian of the brief. You remain the guardian of the clients who comes to you, who remain the guardian of the people whose tears, who have tremendous faith in you. And I say in so many public places that the lawyers are the most trusted, has been the most trusted profession. Because, give you a small example, at least we had that. When a client comes to you, ask him to sign, he'll just sign it. He will not read a single line. And many a times he will keep blank paper signed. He will not give it to his wife, he will not give it to his father, he will not give a blank paper to his son, he will not give his blank paper to his best of the friends, but he will give blank paper signed to an advocate whom he has known only 2 days back. That's the amount of confidence a client has in you. And that you have to repose that confidence. Unfortunately, I do not know nowadays, client sign karke deta hai, nahi deta, I have no idea about it. But yes, in our time, because again I come from farthest part of the country, Guwahati, and that place, it's impossible for any client to come twice. Even if once they have to come at that point of time, it will take 40 hours one way, 40 hours going, and then 24 hours staying here. It's impossible. Sign, get the paper signed, keep it, but that's a very big trust. What I'm saying is, the ethics which we will be discussing today, mainly for the purpose of the paper examination, but otherwise, the amount of trust which they have, you have to serve that trust. You have to, come what may, the trust must not go. If the trust of one lawyer goes, the entire community is at fault. That's what we have seen many a time, that the lawyers are saying, are known as so many things which we have changed that perception of the person which I am talking, I don't want to name here. The lady who came to us for something voluntary work on behalf of someone, they say, I can use that expression. The lawyers are like vultures. Koi aata hai to uske par gir ke aise padate hain. I'm like, that's your perception for the time being. Give us some time. We gave some time. She gave us some time. We did some pro bono work. Then she changed. Yes, they are serving the people. They are the healers of injustice. So you have to serve as healers of injustice. Let's now come to the topic for which Friday evening 5 o'clock you are all here, not to hear all these lectures by me. So today we are discussing paper 3 regarding professional advocacy and professional ethics. As I said, this is important not only for our examination, for the entire legal community, for the entire society. Keep that in mind while answering this. You will get good answers and you will get good marks as well. Because what in professional ethics, what I found from the syllabus, you have only 4 topics: Advocates Act and the reported cases, cases relating to contempt, especially advocates, regarding advocates, Bar Council of India rules, and the Supreme Court rules 2013. These are the 4 headings, and that's the syllabus end. We have something on the website of the Supreme Court of AR examination, a list of materials on ethics, but that also says illustrative and not exhaustive. I find last 3 papers, 2018, 2019, 2021, questions have come which are not in that list. So that is not the complete list which is, and you think that you read those cases and it will complete. I don't think that will be complete. That is again illustrative and not exhaustive. I have prepared a small list of cases with notes on that, on each of the cases. I've shared with Debra. They will share with all of you with a compilation of those cases, which are 29 cases. Most of them are from that list, but I have prepared one page or what are the facts of the case and what are the ratio of those cases. My colleague has been the most important feedback. I have just corrected it. So that compilation, which is about 600 pages of the entire, all the case laws are there with the, and sort of a head note one can say, but it's one page. What are the facts and what are the ratios? That will help you to great extent to, in the preparation of your examination which is coming. Because we have all lost contact with writing papers. And especially I find that in the Advocate and Record examination board committees also we have great debates, and I like your input straight away. Whether you want the typing thing or you want the handwritten thing.
Typing.
Yeah. Great. We had a big debate because a section of our friends says that no, we must switch over to. I said that all of us doesn't come from Delhi or Bombay. We come from faraway places, and still I know many lawyers who brief me. मैंने बोलता हूँ उसको send me a link. We'll have an online. Sir, मुझे link भेजना नहीं आता. आप ही भेज देना मुझे. We'll send them. So we have to be practical about it, and typing etc. All right. As an examiner, I would have very comfortable in reading. I really have difficulties in seeing the paper which are bad handwriting. So again, handwriting, please keep a note. These are small tips. I'm not examining papers anyway. I examined earlier. So, but writing neatly so that the examiner can understand. When I was examining some of the papers, I have kept it very. इसमें तो 2 घंटा लगेगा मुझे एक paper देखने में. Not because they have written too much, but handwriting is not legible. And I don't blame. My handwriting is so bad that I can also take time or many लिखाता है. So anyway, but then when you are pass examination, you have to see from the examination perspective. When you address the court, you have to see from the judge's perspective. कि judge क्या सुनना चाहता है? हमको वही बोलना है. Because ultimately, what judge says is the law, especially Supreme Court. In an examination, what the examiner wants, you have to see that. An examiner wants at least a good handwriting, neatly written, and very specific to the point. Don't see that all like किसने इतना paper ले लिया, इतना extra लिया. 3-4 pages of each question would be sufficient for you to write. To the point, focused, good handwriting, neatly done. Now let's come to the subject. Now we have Advocates Act. All of you must have read it. But always I find that you want to score extra marks, something comes, give a little history of it. You have to know little more than others. That's how you get the extra mark. Get some history behind it. Advocates Act was in 1961. Before that, we had different acts like Bombay Pleaders Act, Legal Practitioners Act of 1879, then India Bar Council Act 1926. Then there was after independence, it was thought that we must have a comprehensive law on the subject. So, an All India Bar Committee was constituted by the Government of India, which made its report with Justice S.R. Das as the chairman of the committee, Mr. Sitalwad as a member of that committee, and some advocate generals. Please put this, if you get a link of putting this, please put it. Oh, the examiner says, he knows quite well, he studied it thoroughly. It's not just read something and then answered it. Put that, if possible, if you can link it. Then there was a Law Commission was asked. It was the 14th report of the Law Commission 1956, which gives a report and which said, yes, you must have a unified bar council, which should have the power. And they said that there are 5 functions of the lawyers, and which I also came to know from this, that we have functions other than what we do in the court. They say counseling is the first, which we call now mediation. Advocacy is not knowing the law. Advocacy is knowing the judge, not personally, what the judge wants to listen. That's the advocacy. Improving his profession, the court and the law. That's the third responsibility here. Leadership in molding public opinion. That is all the Law Commission has said in 1956, on the basis of which Advocates Act is enacted by the Parliament. And the 5th is unselfish holding of public office. These are the 5 things. You can keep in mind what the responsibility, you can say Law Commission 1956 has said under Mr. Sitalwad. These are the 5 responsibilities of the Law Commission recommendation. The examiner will find out you know much more than the examiner. That's good. Sometimes when I examined the papers, I found that yes, I've been enlightened so much with the certain responses, certain views expressed by, I never thought of it. And I thought that एक question to the 15 I cannot give 16, but at least I'll give 15 itself. There have been instances in that. So this is what will enhance your marking, because today we are discussing only about the marking in the examination papers. So based on these two committee reports, one is the All India Bar Committee, one is the Law Commission 1958 14th report, the Advocates Act. And Advocates Act, for few sections, most of you must have read it, but just to highlight it and from examination point of view, Section 29 confers the exclusive right of the advocates to practice in the court. Nobody else can come and practice. He himself can do it, but nobody else. So that is a statutory right which is given to you. And any right comes with a responsibility. This is Nagarathna said, what are our responsibilities? We must follow that. And also this is unique, that once you are enrolled in the roles of the State Bar Council, which virtually comes from the Bar Council of India, you are entitled to practice in any court, including the Supreme Court. Advocate and record is additional qualification, I will say, recognition of that. But again, in various parts of the world, perhaps you have to have different enrollment at different places. You can straight away graduate and enter the Supreme Court on the next year once you get an enrollment. That again, right is given under the Advocates Act, Section 30. It's not comes otherwise anywhere else. Section 34 empowers the High Court to frame rules. Who are the advocates entitled to practice in the High Courts and subordinate thereto? I'll come to Section 34 importance regarding strike and contempt, etc. Because there is a big debate as to whether under the contempt you can debar it. What is the source of power? I'll come a little later. But Section 34 also, normally I also have never applied my mind that there is something like Section 34. We all see Section 35 and that's the misconduct part of it. But this is also important for the High Court is being given the power to make rules who should be permitted to practice in the High Court and the court subordinate thereto. And Chapter 5, which is the relevant for the misconduct part of it, Section 35 to 41 relates to the conduct of the advocates and the disciplinary power of the Bar Council. 35 says, and this is very important, that the State Bar Council on receipt of a complaint, if it has reason to believe, this reason to believe is also many times the questions are there, what is reason to believe, at what stage reason to believe. And you are guilty of committing professional or other misconduct. Now it is very wide. It's not only professional misconduct, even if you have other misconduct, which illustrations I will give you with reference to case law, generally saying is no good because we are preparing for an examination. With illustrations, it becomes more easier with a decided case law. So the expression professional or other misconduct is very wide, and it can be, disciplinary action can be taken on the basis of that. And what can be the disciplinary action that is also given? That can be reprimand, there can be suspension for a period which the Bar Council will think or the appellate body will think, which is the Bar Council of India and the Supreme Court. And third is the removal from the permanently from its role for if it's a very serious misconduct. So it covers misconduct in every walk of your activities, not only professionally, even if you are abusing someone on the road. Somebody says, and it's not befitting the status of an advocate because we are called a noble profession. Anyway, we are called noble profession. How many persons in the society today believes that we are a noble profession? We have to ponder ourselves. We can't blame the society. You have to ponder ourselves why society is not giving us credit cards, why banks don't open, why the people doesn't give us the houses on rent. That's again a reflection on the lawyers as a whole. We have to change that reflection. That's a responsibility which you have, not for the examination purposes. Please keep in mind that's very important for this society at large. And I'll just like to quote one of them and then come to the further, that the legal profession is known as a noble profession having high traditions and has been catering to the needs of the society for a very long time past. Thus, the members of this profession are expected to uphold these traditions and serve the society with sincerity and honesty. If such are the expectations from a noble profession, its members must conduct themselves in a way which may be worthy of emulation. By doing any act which is contrary to the accepted norms and standard of his profession, a member of the profession not only discredits himself, but also brings disrepute to the profession to which he belongs. By acts, the credibility of reputation of the profession as a whole comes under cloud. If any member of the profession falls from the standard, he deserves punishment commensurate with the gravity of his conduct. Just keep these lines in mind. And then we further sections you must have seen, section 34, 36, Bar Council of India has similar power to deal with misconduct. Under section 36B, the State Bar Council does not decide within 1 year, the case automatically gets transferred to the Bar Council of India. Section 37, Bar Council of India has the appellate power against the original order of misconduct, guilty or otherwise passed by the State Bar Council. Section 38, Supreme Court has the appellate power, and the Supreme Court has said appellate power means we can do original power also. Because we have failed. Again, initially the courts have been lenient. I'll come to the case law, which according to me perhaps led us to think that we can do and get away with anything. That forces the other agencies to take over on us, which statutorily we are entitled to take upon us. We don't take corrective steps, somebody else will come in our house and then say that yes, come to a now. Please don't allow that to happen. And what is important is the disciplinary committee of the Bar Council under section 42 had the power to summon witnesses, receive evidence, examine witnesses, ask for discovery of documents, just like a civil court. That again, disciplinary committee has been given statutory powers of a civil court with regard to summoning, etc. Keep in mind, I do not know, some examiner may ask you about what are the powers of the disciplinary committee. Do they have the powers of the civil courts, etc. also? Yes, they have a power of the civil code, section 42, to some extent of summoning the witnesses, to the extent of discovery of documents, requisition, public record, etc. etc. So these are the provisions regarding the Advocates Act. Now we have the Bar Council rules framed under the section 49 of the Advocates Act, which gives the power to the frame rules. And part 4, chapter 2 of the rules make detailed provisions regarding standards of professional conduct and etiquette. Chapter 2, part 6, chapter 2 deals with these rules regarding standard of professional etiquette, and preamble to the Constitution gives the light as to what should be your standard of professional conduct and etiquette. Read that preamble also, which has 3 or 4 very important things. Befitting its status as an officer of the court, that's the first thing it said in the preamble. You are a privileged member of the society. Act as a gentleman. I don't know, I was trying to find out feminine version, so who can enlighten me. What would be the feminine version of gentleman? Gentlewoman or a lady? We call it ladies and gentlemen. I was struggling because my heart before time English mein. So I have not been able to get an exact expression of a gentleman. Is it gentlewoman? I do not know. So can you no?
So you carry on and we'll.
All right. You tell us it. And the third thing, finally, it is fearlessly uphold the interest of his client. You have to uphold ultimately you are representing the client. But it does not mean you indulge in unfair trade practices, unfair things. That's why filtration is required. आपको client कुछ भी बोलता है तो you just don't put it. You require filtration, which ultimate aim is he is come to you for a particular relief. He is in distress. He is in pain. You have to remove his pain. But how do you remove it? Don't go by his instructions only. ये कर दीजिए. Nowadays people come on like ये case law हो लगे ये आप ही बहस करो ना फिर सारा case law. ठीक है. Take his input. Don't say that all right. I know everything. Many times we miss it. Many times the clients give us some case laws because he is concerned with that. We have other cases also to handle. We may not do it, but then feel yourself that you are at the switch pinching you. Then proceed further. That's very important. Then, as just Nagarathna said, you will please read it from there. There is no point in my saying it. Section 1 says duty to the court. My other colleagues have given speeches. Perhaps they have told you that they are duty to the court. They are enumerated there. Then they are duty to the client, which are enumerated there. In section 1, duty to the court. Section 2, duty to client. Section 3, duty to opponent, which is there. And duty to opponent, I find one is very important, which is mentioned there. That you must fulfill the promise which you have made orally to the other side, which I find in the Supreme Court it is there, most of the High Court, most of the places which is not there. Lower courts, or I shouldn't be blaming anyone else, but if you have told the other side in good faith, we will do this. It's not recorded anywhere. Please don't resile from there. No, I have not said. This is not what I have said. Because good faith between colleagues is very important. I find it is there. Once we say, all right, we'll agree for an adjournment, and the court will go and vehemently oppose it. That's not fair. That's not fair. You can win one case, but then that will ultimately lose your reputation. If you have agreed, you have agreed. If you have said, otherwise you say, I don't agree, because ultimate interest is your client. You don't agree for the convenience of the other side. You are not here to make friends inside the court. As Justice Nagarathna has said that don't mingle with the other side advocate. Well, we know how to what extent we mingle. We fight, we come back for a coffee, go again fight. But with one rider, if your client is with you, don't mingle with the other side. He will have because he won't know our professional requirement. He will always think, वो तो उससे मिल गया था. That impression is the worst impression according to me. If the client thinks his lawyer has met even worse than the judge, according to me, because he has reposed confidence in you, and he has come to the judge for a decision in his case. But if he believes, even whether you are rightly or wrongly not done, but if he believes genuinely that my lawyer has compromised his position with other side for whatever concern, that's the worst thing to happen. Don't have it. One of the things, many times I say, we have friends coming from outside, we say, copy peete hain jaake. But if the client is there, avoid that. Because he will have that perception, wo usse mil gaya. Used to doing some important cases at some other forum, and then used to have lunch together. I used to host lunch. हम लोग साथ ही lunch करें. वो कहता, आप क्या बहस करोगे? उनका तो lunch खाते हो आप. कोर्ट के अंदर तो बाकी बहस करते ही थे हम लोग. We'll fight. But that's a perception, because that's how it is believed. And there is a section 4 which deals with duty to colleagues. I told you duty to court, duty to client, duty to opponent, and duty to colleagues. In that you will find as to this, the what extent you can advertise yourself, whether you can actually advertise or social media or website, to what extent. There is a schedule given in the rule under rule 36 of this chapter 4, which I am saying, under the heading of duty to colleagues. I didn't know that it is a duty to colleagues not to advertise yourself or to not to tell yourself what we've done. But they have given certain things that you can give. You can create a website today. Social media, you must accept the technology. I'm also trying to understand and accept the technology. Everything from this. I had very difficult time to do this, but I'm trying to learn. You must use technology which is available. At earlier point of time, you used to see SCC online, SCC yearly digest. Before yearly digest, you used to see each one of them. Used to make notes. Slowly, the technology had come. SCC had come. SCC online. Search has become easier. So you must use the technology. But here also you must use it to the extent it is permitted. Especially website thing, it is said that, and please make a note, what are the permissible use of websites. You can create a website, but it only gives a specific format, which says you can only mention name, address, mobile number, email ID, enrollment number, membership of the bar association you are, academic qualification, area of practice. That's all. But I find that many websites, I was checking it, many websites say, these are my client, I've handled this case. You're not supposed to do this. You cannot do it. This is a professional misconduct. It also says you cannot write in your letterhead, I'm the president of so and so, I'm the former president of so and so, I'm the former president of Supreme Court Bar Association, I am a former judge of the Delhi High Court, I am a former judge of the Supreme Court, etc. Etc. Supreme Court judges don't practice law, etc. But you're not supposed to, you're not required, you're debarred from doing this. That is what, please keep in mind while answering it also, what all you cannot give on your website, that must be known to you. Because today we are talking what is in the letters, what is the requirement of law on theoretical basis. And one thing is also important, we all talk of charging high fee, etc. Some of my colleagues, my fee is very less anyway. But I can share. Don't laugh like this. No, why I am saying it, there is a provision in the Rule 38 that an advocate shall not accept fee less than the fee taxable under the Supreme Court rules from his client if he is able to afford. So there is a provision to say that you cannot charge less than that. But this is also very interesting. So why I'm highlighting this, you see something of interest which the examiner do not know. If the examiner knows everything, examiner हमारे say कौन ज़्यादा पढ़ता है, देख लिया जाए, but something sticks to him. Oh, he knows this also. Let me check up whether this is correct. If you find that yes, one thing is correct, बाकी को तो ठीक है, सब अच्छा ही हुआ होगा. So those small tips are very important for you to know. So these are the basically Bar Council rules. Thirdly, the Supreme Court rules, which also we require. This is Nagarathna said that Supreme Court rules are there for advocate on records. Again, who is entitled to appear in the Supreme Court is anybody who is under the State Bar Council is entitled to appear. Anyone in the appear. That is what the Order 4 of the Supreme Court rules. You must have all seen. Otherwise, please make a note. Order 4 of the Supreme Court rules 2013 deals with the advocates. A partying person can appear only if you satisfy that yes, I can represent and I will use good language in the court register to give a certificate, then only he can appear. And of course, you must also write senior counsels cannot appear except briefs. There is a specific prohibition that he shall not fight and cannot appear without an advocate record. So whatever I am today, I am depending on all of you tomorrow becoming advocate record. Otherwise, I have, the court can recognize who you are record. Sorry, we don't recognize you. And they are entitled to say that. Unfortunately, Nagarathna said that they must insist on that nowadays. And it is not filing, which perhaps Justice Nagarathna has emphasized, which is not doing this for filing. You are achieving a further ladder in your profession. And then you are, again, this for examination purposes, you are required to keep books of account of the advocates, of the clients, each client wise. That again, someone may ask you a question whether you are statutorily required. Now, as an advocate record, you are statutorily required how much money you have received, how much is outgoing, what's expenses, senior counsel or any expenses, court fee, etc. These are requirement of the Supreme Court rules. And again, misconduct when it comes, the Rule 10 specifically, it goes further. It says, Rule 10 of Order 4 of the Supreme Court rules, guilty of misconduct or conduct unbecoming of an advocate record. Why? Unbecoming of an record. मेरे हिसाब से this is unbecoming, इसके हिसाब से वो this is unbecoming. So it is anything under the sun comes unbecoming of an advocate record. So your conduct has to be very, very high. Anyone thinks it's unbecoming of an advocate record, it's a professional misconduct under the Supreme Court rules, and your name can be removed from the register of the advocate record on that basis. There in the Advocates Act, in the Bar Council rules, and in the Supreme Court rules. Then, whenever you are asked, because the theory paper is so less, you have to depend on case law. There again, the additional marks come from there. I prepared some sort of a compilation of case law, let us say 29 cases which according to my important, some are left out there also because couldn't complete the entire thing. But there you must see for the facts of what are the facts of the case and what is decided. Don't go just pick up one line from any judgment and do this. I'll hurriedly, you can tell me when, because Friday afternoon is quite late and quite boring, but then we are all appearing in the examination. That's what important is. So you have to be thorough. And you want to say? No. You share it later on. I'm just telling what are there. I'm going to. Please continue. I'm going to continue and then tell you till one of you are here. And you can leave if you find me boring. It doesn't matter to me. It doesn't matter. And I'll go chronologically. Some of the case laws on professional, because three areas which are there. One is professional misconduct. Another is contempt and the professional or taking disciplinary action. And third is the strike, which is again becoming really bad. Fortunately, we don't have a strike in Supreme Court. Once or twice it was tried, but it was failed. Fortunately, we don't have. Presently, Justice Call, I will come to that. On strikes on any issues. You just think, आज तो बहुत गर्मी लग रहा है, आज तो नहीं काम करेंगे, strike हो गया. It's happening. one can laugh away and see that how can it, but this is happening. See the plight of the person who is in bail, who is in jail, or he wants a stay of eviction. Anyway, I will come to those details little later, some other day maybe, on a cup of coffee, which I will invite, and then we will have a talk on it. And let me give you really some of the cases which are there. The first case which I kind of found is VC Rangadurai. You will get all these judgments, perhaps they will circulate it, you can note it, but first is VC Rangadurai, which is 1979, Justice Krishna Iyer was the judge, was the majority judgment, in which he was to file two cases. The client gave him that you file two suits based on two promissory notes. He filed one and said, I filed both. The State Bar Council found him guilty and suspended his license for 6 years. The Bar Council of India was benevolent, they reduced it to 1 year, and Supreme Court was further benevolent, saying that no, he is a young guy. Later, he is given his volunteer service for volunteer services. He was just reprimanded and then suspended for 3 months by the time the judgment was given, and then said that he will give legal aid. As if legal aid, jisko to dega wo, he should be the worst lawyer should give a aid. Best of the lawyer has to give a legal aid. And I always have a grievance that the lawyers are not giving sufficient legal aid. Lawyers means some of them us are given, some of us don't have time. It should be made mandatory for every lawyer, every bar association, especially senior lawyer, that you have to appear in so many legal aid. Otherwise, we will, at least which is in our jurisdiction, we will, at an advocate court, we will not brief you as a senior counsel. SCDA will remove you from SCDA membership. Let's take that. Anyway, that's a different thing. So, what Justice Krishna said, and he hoped, and it's very difficult for me to read even, I tried to do it, a therapeutic touch, a correction twist, a locus potency may have rehabilitative impact only if we experiment unorthodoxly but within limit parameter of law. What the experiment it is, all right, let him serve for some time as a legal aid counsel only and not as a private lawyer. So perhaps that will help him. But then again, legal aid counsel is not that you are doing a charity and then you give a person who doing legal aid and that is a punishment sort of thing. You don't have that. But anyway, at that point of time, I am saying in 79. Slowly, when I come to slowly how the courts have changed because we have not corrected ourselves. The next judgment is P.D. Khandekar in 1984, where a couple approached a lawyer, I need a marriage certificate. And I need today because I have to go back today itself. And he said that there is only one way for marriage certificate. If I register marriage, you have to give a notice, there are requirements, etc. Will show that all like you are married in a temple and you are certifying himself. So he prepared a false affidavit, knowing it fully well that they are not married, saying that yes, we have married in a temple and give us the certificate on that basis. There was another misconduct found in him that he gave advice if you to transfer something, there is a stamp duty which will be taken, make an affidavit transferring, knowing that he does not get any right, but then charge some money and then do it. Here also, the Bar Council found misconduct, etc. But Supreme Court said it is not misconduct, it may be wrong legal opinion. It cannot be wrong legal opinion. That's why what I am saying is in earlier days, Supreme Court was kind enough because they thought, all right, it is a mistake, bar, novel profession, it is by way of an exception which is happening. That's why in that case, Supreme Court reversed the order of punishment, saying that it is not a legal misconduct. It is not a misconduct. The advice may have been given wrongly. Wrong advice is not a misconduct. So, he said that nothing is to happen to the law. Third case is John D'Souza of 1994. This is Pandian judgment, where somebody executed a will, and after the person died, their legal aid approached me and said that I will not give you, I will charge money. It was not returned, and in that case, license was suspended for 1 year. Again, that is the question of trust. If some trust is on me, then you have to fulfill that trust and cannot defy the trust. That's a serious misconduct. Next case, which you can note, is Hikmat Ali Khan of 1997, where a person was convicted of a criminal case and who was happened to be an advocate, attempt to murder. because he assaulted his opponent in his personal case. So it was not in the capacity of professional that he misconducted himself, but in the personal capacity he misconducted. There the Bar Council suspended license for 3 years. Now harshness comes. The Supreme Court says cancel his license permanently. So slowly the theme has changed. The Supreme Court mindset is changing because we are not behaving as we ought to behave, as we should behave. Next judgment is Harishchandra Singh, because in that case a lawyer was engaged, his junior was also a power of attorney was executed in favor of the junior, and based on that power of attorney, he sold the property of the client to the main lawyer's father. It's a serious misconduct. Again, matter of trust. But these are all reported cases. You can give illustration. When they say, give us some illustrations of cases which are misconduct other than in your professional capacity. This is professional, or give us some cases of misconduct of professional harassment with decision to leading cases. You will get, please give these facts that in that case it happened. And you may not remember the citation. If you can remember the citation, it is well and good. If you don't remember the citation, at least tell the name of the case and a year. That will be sufficient. Then again, sometimes in LC Goel's case, 1999, where the advocate misappropriated the amount received as court fee. Many times I find even some people say court fee to 10,000 रुपये कम से कम, High Court में लगता है 500, Supreme Court में कहाँ 10,000 रुपये कम से कम लगेगा. Don't charge your fee whatever you want, but don't mislead. The court fee is so much. At today's world, everybody knows now. Digital world, we are not able to confine everybody. Just Google it, SLP में what is how much fees to be paid. Everybody knows. But if you charge, it's a serious misconduct. Again, the license was suspended for 2.5 years on that basis. Another thing which we do is RD Saxena case of 2000. Do we have a lien on the files? Some file is given to us. We are conducting cases. The client case give us no objection, and I don't want you to continue for whatever reason. He got a better advocate. He is not happy with you, despite you doing better. Can you say that I will keep the files and not return? No, this is a serious misconduct. You cannot do it as a decided case of RD Saxena in 2000, where Justice Thomas has said. Here also, this Justice Thomas does say it's a very serious thing. The Bar Council of India suspended his license for 18 months. But the Supreme Court said we'll reprimand him and leave him for this time. Next time, karo with the forward. But then again, the leniency is not good many a times. Especially we are educated people. We have all studied law. Now we are 5 years down the line in the profession, which is a good period. That's the reason advocate record immediately a person can become a judge the next day. He becomes an LLB degree, a patient examination becomes a judge or the magistrate, but advocate record you cannot become at least 5 years or 5 years. Another case, Dastane, NG, Dastane. Here also we do many times, and adjournments are sought. We have got an entry order, we want to delay it. Get an adjournment at any time. And it is not unknown that we write he is not well. Take it, us ground पर तो adjournment मिल ही जाएगा. We will get that adjournment. But there, if you are caught, because in that case it is found you have got an adjournment, sought an adjournment on health ground, and in other course you are appearing. Give specific instances. Why I am highlighting these are generally known. But give specific instances. It was held that if you give a false reason to and personal reason, which is false to your knowledge, as a ground for adjournment, this is a serious misconduct. And Supreme Court said an advocate abusing the process of law is guilty. And again, the reason to believe comes here. The reason to believe under Section 5 is for reference the matter to the disciplinary authority. Now, if an allegation is made that he has sought an adjournment in A court, in B court he is arguing, the Bar Council did not take any action, but the Supreme Court said the reason to believe it is sufficient. It is not malicious. I know I stopped doing that. Sometimes you withdraw the cases. Again, in the slide, I am just telling you generally. We withdraw the cases in the interest of the client. The court is not with us. Let whatsoever permit me to withdraw it. And the court says, all right, on request we withdraw. He files a suit against you. Who asked you to withdraw it? You have found it there. So that's again, please don't withdraw that. This is not, please don't withdraw cases unless you have a written instruction, at least on WhatsApp. I've stopped doing that. We had a case as an advocate court. There was a senior counsel who later became a judge of this court. There were suits against us filed. Because we withdrew it, he said that I never asked. Let the court dismiss it. It may be dismissed. But for withdrawal, you seek instructions. Either he is present in the court or immediately thereafter you send some message saying that because of this, I have withdrawn it and it was in your interest and on your instructions I withdrew it. Keep yourself a little safeguard in that. That's very important to do it. Again, another case where there was a landlord-tenant matter in Nagarathna, 2004, where the landlord was advocate, he was doing his own. During the court proceedings, he assaulted the tenant, not as an advocate but as a litigant. Bar counsel did not initiate an action because the tenant does not file any FIR. But the Supreme Court said this conduct is sufficient misconduct and is wide enough to be under Section 35. And it interpreted to mean an improper behavior. What is misconduct? Other misconduct. Improper behavior, intentional wrongdoing, or deliberate violation of a standard of behavior. Again, these are very general terms, but then everybody know that, all right, what is expected us from the society to do that. But Supreme Court said all these things, but again, he said that the incident took in 1995, we are in 2004. We reprimanded him and leave him like that. So Supreme Court has been sometimes yes lenient, sometimes harsh. But then, according to me, whenever there is a professional misconduct and you yourself think it's a professional misconduct, it should be dealt with lightly. Messages to go to others, not to only for you. It messages to the entire community which is there. And lastly, Justice Nagarathna's bench, Anjina, which is 2021, because under the Bar Council rules 36B, Bar Council of India, all the complaints made to the State Bar Council, if not disposed of within 1 year, they get transferred to the Bar Council of India. Now, Bar Council of India, there is no time, so you don't decide cases within 1 year, within 2 years. It was pending, so it came to the notice of the Supreme Court that Bar Council of India, as on the date of the order, December 2021, 1273 cases were transferred to the Bar Council of India under Section 36B, were not disposed of. They found out, give us the year-wise. They say because of 21, we had pandemic, so we are not able to dispose of. Court found 490 cases of the year 2016 to 2019. Give these figures also if it comes to it. This again enhances your seriousness, or when the examiner is seeing your question papers, give some figures, it always say that you are meticulous. That gives his interest. That shows you are not just writing averagely or generally. If you give some facts and figures, this helps. Or some cases are not asked on. You show it because this 2021, I don't know whether it will be there or not, which is not there in that list of 47 cases with the Supreme Court website. Give some way to say, latest in the Supreme Court, they have not disposed of. That's why Supreme Court asked for figure. 1273 cases were found pending with the Bar Council of India, which were transferred, not disposed of. Supreme Court found 490 cases from 2016 to 2019, pre-pandemic cases. And the Supreme Court directed you dispose it of within 1 year because you have transferred it, State Bar Council is not in it, and you yourself are not doing it. They say we give us a report. I don't know what thereafter it has been said, but this judgment also deals with all the earlier cases. So while we're answering the questions, give us specifics. Don't write vague answer. Give specific, give reference to the case law, which will definitely help you to get marks, get better marks. Now the second issue, which is a very debatable, and is contempt jurisdiction of the Supreme Court and the suspension of license of the advocate. The first, it started with Vishy Misra case from Allahabad High Court. He was a big bar leader. threatened the court, if you don't give me order, don't ask me all these questions, I will get you transferred. We'll introduce impeachment proceedings against you. You don't know me. Those were the words. The High Court just referred the matter to the Chief Justice. Chief Justice of the High Court referred the matter to the Chief Justice of India. Matter was taken up on the judicial side, and they found the advocate used very bad language, intemperate language in the court. They awarded sentence of imprisonment and suspension of license also. Now, when it comes to the suspension of license, yes, Supreme Court 142 can do anything because there is no one above them. That's why they are right, not because they are right. They are right because there is no one above them, and not because they are always right. This was taken up by the Supreme Court Bar Association 32 petition, saying that the power to punish an advocate for a misconduct lies with the Bar Council of under the statute. You cannot take this power. And there earlier Vinay Chandra Mishra is 3 judges, where Justice Sawant was the main author of the judgment. The Supreme Court Bar Association in 5 judges, which is in 1998, all these cases you will get on that list, which is there in 47 list also. That court can punish for contempt, but it cannot take disciplinary action or suspending license, because that power rests with the Bar Council of India. Though it is, your powers are wide under the contempt, under Article 129, they can punish for contempt. It's a constitutional power. 129 for the Supreme Court, 215 for the High Court. You have 142 powers, but the court says power to punish contempt, though wide, yet limited, does not include the power to determine whether an advocate is guilty of professional misconduct. You cannot, because this is a summary jurisdiction. When there is an allegation of misconduct, you give a notice, you give a hearing, you have a cross-examination, there is summoning of witnesses, etc. You cannot do, and that law is a 5 years. But it has been diluted because of the further things which, unfortunately, a few minuscule persons from our community has done. The Supreme Court Bar Association 5 judges still says that the Supreme Court has no power to initiate disciplinary proceedings, because that lies with the Bar Council of India. Then the Kerala High Court in the Bar Council of India versus Kerala High Court 2004 judgment, which say that the High Court framed rules saying that if it is found guilty of contempt, you are not entitled to appear in the court unless you purge the contempt. Again, what is purging is you have to express remorse, you have to express, genuinely feel, court must feel that yes, they are. Yes, such rules can be framed, the validity of that rules was upheld. Immediately thereafter, there is another case of Madras High Court arising from the Madras High Court rules, which is of 2019, where Madras High Court rules framed 14A, saying that High Court can debar an advocate from practicing, found to misconduct. Those rules were struck down by the Supreme Court, saying that it cannot be done because Supreme Court Bar Association in judgment. But the question is, if it is in a contempt jurisdiction, you can say you will not appear in my court or subordinate thereto. That is, Section 34 of the Advocates Act also empowers the High Court to frame rules. So they can frame rules, not generally misconduct. If you have committed, first it has to be shown that you have committed a contempt. In punishment for conviction of contempt, you are not allowed to appear in the court, my court, or in a court subordinate thereto. This is the distinction, not suspending his license, but not permitting the court appear in my court itself. Then we have infamous case of R.K. Anand, where a senior counsel was tampering with the witnesses or tutoring the witnesses in association with the public prosecutor. He was debarred from appearing in the court for some time. Reference was made to the full court to take out the senior count for some time. And then again, Maipal Singh Rana, 2016, there is a judgment, which is again a very nice judgment, which says, which is again a court threatened a judge, civil judge, with intimidated bad language. Here the distinction lies now, how the balance is treated. Earlier the courts have been soft, State Bar Council of India did not take any action. In the Supreme Court issued notice to the Bar Council of India, do you propose to do anything? They did nothing. In such circumstances, Supreme Court says, in view of the failure of statutory obligation of the Bar Council of the state of UP and the Bar Council of India, this court has to exercise appellate jurisdiction, because remember that the Supreme Court is an appellate jurisdiction over any disciplinary action taken by the State Bar Council, thereafter Bar Council of India, and the Supreme Court thereafter. They say this court has exercised appellate jurisdiction under the Advocates Act in view of the proved misconduct calling for disciplinary action. The Supreme Court suspended the license of the advocate initially for 2 years and for a further period of 5 years if as a probation period, one can say that. Then in the Prashant Bhushan's matter, we all know 2021, this is not in that list, but please keep it in mind. In that, Prashant Bhushan made 2 tweets, read that judgment of 2021, 1 SCC 745. You will get all these, our colleague will circulate you all these citations, etc. He made a tweet that Chief Justice of India is riding on a bicycle of a bike of 50 lakhs of a BJP, owned by a BJP person, and he is keeping the Supreme Court under lockdown. You can write that, but it was in a bad taste. It was in that reference. Supreme Court was locked down because of the pandemic. It was not that he's enjoying and locking the Supreme Court. He may have said it may not be appropriate. He may have taken a photograph nahi hota to that nahi hota. Kiska bike tha, kya nahi tha. Anyway, I'm not on the justification of it. I'm saying this is what was one tweet, and the second tweet was that when the historians will see how democracy has been destroyed in India without a formal emergency. They will mark the role of the Supreme Court in this destruction, and more particularly the role of 4 last Chief Justices. He has said about the Chief Justices being corrupt, etc. That is still pending. But these were found to be criminal misconduct. Under Article 129 of the Constitution, the Supreme Court has the inherent power to deal court of record and misconduct. You cannot vilify a judge only because again the question is, can there be a contempt with regard to an individual work of a judge? Can you say no, he is wearing such a expensive suits? Suppose we take salary is 2 lakhs per month, he is wearing a suit of 5 lakhs, next state another 5 lakh. Does it amount to misconduct? If it relates to personal capacity, no misconduct. You cannot, it's not a contempt. Misconduct is different. We are talking about contempt along with misconduct. It will not be a contempt, but it regards to an administrative work, because what the tweet says is lock the Supreme Court. There the Supreme Court says, if you only say he is riding a bicycle or bike of 50 lakhs, that's a different thing. It may not be a contempt. But coupled with the fact the comment was with regard to an administrative work of the Chief Justice of India, which was held to be contempt by the advocate. Because fair criticism of the conduct of a judge, all right, if a judge is every day wearing new suits of 5 lakh, definitely we can make a comment. His salary is so much, how can the judge wear a suit of that cost? That will not be a contempt. We can agree. But if you include motive that it is out of the money which is received in bribe, etc., that will be a contempt. However, finally the Supreme Court found that yes, it is to be symbolic punishment, so 1 rupee was the punishment. And again, there is a contempt by a leading lawyer who is my contemporary, good friend of mine. It may not be a contempt, should not be a contempt, whether it's a debatable issue, but once you find a contempt, don't ridicule that, the contempt of the Supreme Court of the Chief Justice of India is worth 1 rupee, and alternative is 3 months imprisonment and debarring of practice. Anyway, and what is important is if there is any question relating to case law, please give your own opinion whether the question is there or not. Just add 1 or 2 sentences towards the end that yes, in my view, this was a possible, this is not a correct judgment, this should be a better judgment, this reasoning should have been there. That will again attract additional marks for you. And the thirdly is, again, Justice Nagarathna was saying about the advocate on record. I could find that Rameshwar Prasad Goyal judgment in 2014 where he was found to filing huge number of cases, not appearing in the court. On one day, court found that nobody is there. They called the advocate on record, Mr. Goyal. He said, "I'm not coming." They initiated proceedings against him. Why should your license should not be cancelled as an advocate on record? He tendered apology and saying that I will not do in future. It was accepted, and then again it was let off lightly perhaps. The Justice Nagarathna said, "No, you're not for signing. We all were advocates on record. We are responsible to the client. In one or two cases, advocates come and then you entertain them. You don't entertain, but your responsibility is to the client. Mean to grow, to be friendly with everyone. Don't be rude to everyone. But doesn't mean we entertain people as such. So, but anyway, that is not the role of the advocate on record. That is not, and especially whenever you sign, at least you have one brief with you. At least you see the list of dates. You must know what is the matter about. It's very, very important. We have friends, some of our colleagues just sign it, keep one brief, keep a track when it is listed. At least open the brief before it is sent. And he said, "Why should I open? I've been paid only this much," that's it. But that's not what you are doing today. So you are doing so much of effort to pass an examination. We have forgot to appear in the exam. We forgot to write nowadays. But you are doing that effort not for signing and then getting a small amount of money for that. Even if you sign file as an help to your colleague, you do it because I was not an advocate, but I was filing my cases to someone. You take the responsibility, but ensure that he is taking a responsibility. Ensure don't file it XYZ. You do not know even on whose behalf you signed. Many times it has happened. I know certain person who happened that he just give him a particular money and then he signs it and they don't know on whose behalf, who is the instructing advocate, who is the client, what is the matter about. Please don't do this. That will be, in one case if you do this, court, then your entire career, entire graph which is gone, it will just slide and then become zero. Pandemic likely to be closed down. So that's again a very important thing which is there. The strike which is so you want me to close now? I won't close, don't worry. So long as some of us are here. See, the strike is creating really trouble. I'll come to a few case laws which are there. Because we all blame the court, there is a delayed disposal today, there are 5 crore cases pending as per the National Judicial Data, which I saw it today morning. In district courts, 4.28 crores are pending. Again, give these figures if it comes to delay and etc. You say as on date, on the date of the paper you find out. As on the date of the exam, today, give a date. As per National Judicial Data agreed, total cases pending in the, and this is just National Judicial Data agreed, just go to that website. It's real time. So if I'm seeing it now and seeing it after 2 minutes, the figure will change. So it is total cases pending in district courts are 4.28 crores, out of which 1.09 are civil and 3.19 are criminal cases. In the high courts, 59.55 lakhs cases are pending, where the civil is much more, 49.79 and criminal are 16.79. Give some factors with this. But when it coming to strike, this adds to your, the pendency, the areas gets added. We will get some figures from the reported judgments of the Supreme Court or recent orders of the Supreme Court. And keep in mind, again, for the purpose of examination, again I am saying, Dr. Ambedkar in his concluding session in the Constituent Assembly speech on 25th November 1959 said that we must adopt constitutional method to redress our grievances, must abandon civil disobedience, non-cooperation, satyagraha, which were the tools against colonial rule. Now we have framed our own constitution, we the people have framed our constitution, so we must adhere to the constitutionally permissible means to redress our grievances. Add this, perhaps an additional mark again will come in that. With this, there are few judgments which has come. The first judgment is perhaps of common cause, which was filed in 1990. There are 2 orders. One of the orders reported in 2006. Citation I have given. By an interim order, there was the issue of common cause, raised the issue of strike. There was an interim order notice to all bar association, bar council. There was a consensus, all right, we will do this. And on the basis of the consensus, There is an order of 7/12/1994 reported in 2006 9 SSC 304 that in rare cases where Bar Association or Bar Council feels a call for strike is given, it must be left open to the individual advocate to be free to appear without any fear or hindrance by the association members of the Bar Council or Bar Association. No such member should be visited with any penalty of expulsion from the Bar Association because he participated in this strike. You can have other forms of protest, wearing a band, hunger strike. Don't disrupt the court proceedings. With this, in 1990 or 1994 order, things didn't happen. Then Mahavir Prasad Singh judgment came in 1999. This is Thomas said. He said that advocates or group of advocates cannot boycott courts and ask the court to desist. If you are retaining the brief, it is your duty to appear in all the dates where it is there. And no court should yield pressure, to the pressure of boycott courts and give dates only, which even happening. And the most leading case is perhaps Harish Uppal case, which is of 2003, where the Constitution Bench declared that lawyers have no right to go on strike or boycott courts. Strikes or abstaining from court is unprofessional. So long as you hold the wakalat from a client, you are bound to appear on the dates assigned. Because it is his fundamental right of speedy trial which you are violating by not appearing, which is trial is getting delayed. And it was hoped that the Bar Council will take necessary action that the strikes or the forcible, those members who want to appear will not forced to refrain from appearing in the court. Then there are Law Commission reports which are again startling figures, 266 report of 2017, based on the judgment in Mahavir Prasad. They say, all right, let the Bar Council, Law Commission look into it. They found in the Dehradun district, advocates were on strike for 455 days in 4 years from 2016 to 2016. On an average, 91 days in a year they were on strike in Dehradun. In Haridwar, they were on strike for 103 days in a year. Can you believe this? But it are all hard facts. Rajasthan High Court shows that they were on strike for 114 days in 1 year alone. Muzaffarnagar, there were strikes in 4 years, average was 115 days in a strike. Tamil Nadu, they gave a figure that 137, 115 days in per year strikes were there. Because they gave for 4 years, 687 days, per year it comes to 137. In some cases, some districts it comes to 150. Some cases, the lowest was 81 days in 5 or 6 districts. So, Justice Chauhan was the chairperson of this law commission. He recommended costs would be imposed on the lawyers for training. Cost of 3 lakhs rupees, which he gave at the highest ceiling. Direct compensation to be paid to the litigant lawyer up to 5 lakhs rupees. And the Bar Council of India must make strict rules as to what they propose to do when the strike calls are given. Many times, in many associations, there are bereavement of the lawyers, there is suspension of work. We don't pay respect by suspending the work. That is often was adversely commented by the Supreme Court in the Hussain case 2017. Then in 2018, Krishnakant Tamrakar case, Supreme Court said that all right, let the central government get data of the quarterly reports, what is the effect on strike. There is no such report, I could lay my hand. In Ishwar Sandhalia's recently in 2020, in 2 states they found, in Uttarakhand and in Rajasthan, they went for strike. I will not appear before particular judges very hard. Rajasthan, all the office bearers were summoned. They tendered and conditional apology was accepted. And now the last one, which Justice Sanjay Kishan call is monitoring, or is now in December itself, I think 16 or 18 December is the next date, where he highlighted regarding Odisha that found that judicial work of 2,14,176, give these facts regarding strikes, it will strike. The one answer will be sufficient to take care of the other answers. Judicial hours have been lost from January to September 2022. And what are the reasons for strike? One is establishing permanent benches. We want in Sambalpur, we want in Gopalpur, we want at various places. Some advocate has died, we are having condolence messages. There is a flood. There is scorching heat. We want crop insurance for the lawyers. There is heavy rainfall. There is some transfer of some judicial officers, which he was giving us relief, he is transferred. These are in the judicial order, these are noted as the reasons for strike. Can we justify any one of us these strike things? And then he directed the Bar Association members of those districts who has called this strike to come and appear. Many of them come and appear, some tendered apology. Then they say that all those their office which they are holding as a Bar Association member must be dispensed with. They will continue to work as an advocate, but they will not be the office bearers of the Bar Association. And now the matter is listed on 12 coming. So this where we have gone regarding this strike thing. Strike, we must protest, we must understand, we must protest, we have a right to protest. But not for, it's a heat, it is flood, not, someone is not able to appear. But that cannot be a matter of strike. Give these facts and figures, some case law. Give the latest case law so that the judges, the examiner will know that we have the latest figure, the known latest figures. This will give your additional mark. With this, I have taken sufficient time on a Friday evening. I am willing to answer anything, but then perhaps many of us would like to go and then take some rest on Friday evening. And I thank Scaora and everyone for giving me this opportunity to interact. And I wish you all the best. And I'm sure that with little care, but now Padna Padta, without basically Padna Padta, that's we have developed that reading, but developed that little very interesting academic. I have been reading all these case laws. I have not read it for brief, but then this is very interesting to read. I have come to know very many new things, which you will come to know if you read it carefully. And wish you all the best. Thank you very much.